My dear brothers and sisters, tonight the topic of our program is titled The Trial of Sheriga, a Customary Chief, Enskinned by the Nayiri. The Trial of Sheriga, a Customary Chief, Enskinned by the Nayiri. I'm going to start this program with a disclaimer. This discussion is purely for legal education and public understanding. It is not intended to prejudice any ongoing case, disrespect any court, or influence judicial proceedings. The analysis is based solely on Ghana's constitution and criminal procedure law. Once again, let me restate the disclaimer before we start tonight's program. The discussion is purely for legal education. Tonight's discussion is purely for legal education and public understanding. It is not intended to prejudice any ongoing case, disrespect any court, or influence judicial proceedings. The analysis is purely and solely of Ghana's constitution and criminal procedure law. It is based on Ghana's constitution and criminal procedure law. Let me also issue a second disclaimer, which is I am not a lawyer and I do not intend or pretend to act as such. Any of the information that I'm going to share with you for the purposes of education and public understanding are based on my research, questions that I have asked of people who are lawyers and their answers. I just want to share with you that information for the purposes of education and public understanding, my dear brothers and sisters. The program also is not intended to diskin anyone as a chief or enskin anyone as a chief. That said, tonight's discussion, the focus of tonight's discussion is narrow and legal. We're going to look at section 57 and 63 of the Chieftaincy Act. And of course, we may delve into one or two aspects of, from the 1992 Constitution. To put everything into context so that the general public will understand what is going on, the trial of Sheriga, a customary chief enskinned by the Nayiri. This discussion is going to be premised on the just ended mediation report presented to the President of the Republic of Ghana by Otumfuo Osei Tutu II. And it is very important to premise tonight's discussion on that so that we can follow the trajectory of the trial of Sheriga closely and make our own informed opinions about what is going on and what is happening. Voice of Mampugu stands for peace in any part of the country, and more particularly the Boku traditional area. We are for peace. We will continue to be for peace. We are also for justice, equity, and fairness, and we shall continue to stand by that. Last but not the least, of course, we are anchored. Our values are anchored on truth, nothing but the truth, my dear brothers and sisters. Now, before we go to the mediation report, let me give you the factual baseline of tonight's discussion. The uncontested facts for tonight's discussion. Number one, Sheriga Alhaji Seru Abagre was enskinned as chief by the Nayiri of Mampugu in 2023, 2 years ago. He is not a registered chief. In other words, his information is not recorded by the National House of Chiefs, nor the Regional House of Chiefs, nor any traditional council. Fact number 3. Naba Aninchema Abogrago is registered as a chief of the Boku traditional area. In other words, his information is in the National House of Chiefs records. Fact number 4. There is admissibility of ethnic chieftaincy dispute in Boku by the state. There is admissibility. Let me repeat. There is admissibility of ethnic chieftaincy dispute by the state in Boku. Fact number 5. Asante Hini was appointed by the state to mediate the dispute, the chieftaincy dispute between the Kusasis and the Mampusis. Fact number 6. Asante Hini presented his report of the mediation to the President of the Republic of Ghana with recommendations therein. Fact number 7. Sheriga Alhaji Seru Abagre was removed from Boku by the military and detained in Accra. He is still in detention in Accra. Last but not the least, fact number 8. Criminal charges have been brought against Sheriga Alhaji Seidu Abagre, referencing the Chieftaincy Act and, of course, the Criminal Code, I think Act 360 of 19, Act 30 of 1960, if my memory of the law is accurate. So this is the background or the baseline fact, uncontested, that we need to start with. Now let's go to the mediation report so that you can have a better understanding of tonight's program. So let's start with the mediation report.
At the commencement.
All right, ladies and gentlemen, get ready, and then let's start with the mediation report. I will highlight certain facts from the report so that we can all have better understanding and education of the trial of Sheriga Alhaji Seidu Abagre.
At the end of the hostilities, the government of President Akufo-Addo had issued a statement stating government's view on the legal position. Both President Akufo-Addo and now President John Dramani Mahama came to a conclusion that historically, governments have intervened to resolve the matter without lasting peace. Again, they indicated that the courts of Ghana had also been invited to resolve the issues implicated in the Boko matter, and their pronouncements have not been respected by other sides if it went against them. As a result, both governments, who now represent the two main political traditions, now take a position that I should define a solution to the Boko situation using mediation, and my recommendations or conclusions shall be enforced by both governments at all times as a traditional solution to the problem. So, it is important to give a brief assessment of the documents submitted by the Nayiri and the Boko Naba, as well as oral rendition of their respective cases, as part of efforts to mediate the chieftain's dispute in Boko to ensure lasting peace. That's an examination of the respective cases of the parties relative to the facts, custom, tradition, and the law will be evaluated and or examined. So, the case of the Mampruses is that Mampruku Kingdom started in Pusiga near Boko and founded by Nabewa at a time when there was no ethnic group in the Boko area called Kusasi. After the demise of Nabewa, Na Tosugu became the Nayiri and decided to relocate the capital of the Mampruku Kingdom from Pusiga to Gambaga, but he appointed a Tingunaba, a caretaker, to take care of his father's shrine at Pusiga. It was further asserted that in the 17th century, the 10th Nayiri, called Na Atabia, decided to secure his territory by establishing garrisons and military posts at key positions that were uninhabited, which led to the establishment of Boko and 5 other towns. The first chief of Boko was one Na Ali Atabia, who was the son of Na Atabia in the year 1721. Furthermore, the Mampruses ruled Boko for over 150 years through 8 successive Mamprusi chiefs before the arrival of the British in the Northern Territories, and specifically Boko in 1907. In 1957, so they claim, the CPP government, through its sympathizers in Boko, elected one Abugrabgo Azoka as Boko Naba. And the case of the Kusasis is that they practiced the Tindana system, where the eldest male person in the clan becomes the traditional ruler, the leader of the clan, vested with administrative judicial and spiritual authority. However, when the British arrived in Boku in 1901, in their bid to advance the indirect rule system, they were not satisfied with the Tindani system, so they decided to adopt qualified Tindanis to become chiefs. And in areas where they could not find qualified Tindanis, they appointed other people as chiefs. The Kusasis further contended that it was around this period that the Mamprusis presented themselves to the British as chiefs of their ethnic community in Boku and got registered accordingly. However, the Tindani position was never abolished as a traditional arrangement. Thus, the chiefs and Tindanis coexisted. But the new Mamprusi rulers became power drunk and started misusing their authority over the Kusasi landowners, hence a decision by the Kusasis to remove the Mamprusi chiefs and replace them with their own. So when the last Mamprusi chief died in 1956, the Kusasis gathered in Boku in 1957 and selected a son of a prominent Tindani in Boku called Bugrago Azoka I to fill the vacancy as Boku Naba. Following the death of Naba Abugrabo Azoka in 1983, his first son was selected in 1984 to succeed him as the next Boku Naba by name Zugran Asigri Abugrago Azoka II. He has continued in that position till date.
All right, my dear brothers and sisters, that is first video that I need us to pay attention to. I have 3 more videos to play from the report. Now, before you understand the trial of Sheriga, you need to pay attention to each of the information that I'm going to share with you from Otumfuo. Otumfuo started by saying in this video that on the onset of hostilities, he was approached to mediate on this matter. So let's take note of the word hostilities reflected in the report of Otumfuo. So when did the hostilities in Boku began that Otumfuo was reached out to mediate? You and I know that it began in 2021. I'm not going to go into what triggered it, but this is an important point because as at 2021, when there was hostilities in Boku, Sheriga Alhaji Sidu Abagre was not enskinned as chief by the Nayiri until 2 years later. In other words, before Sheriga Alhaji Sidu Abagre became a chief per the custom and tradition of the Mamprusi people, Boku had experienced hostilities, violence, ethnic violence for 2 years. Asantehene also mentioned that the Nayiri and Aninchema, or the Kusasis and Mamprusis, submitted their documents to him. He also highlighted that his report was going to evaluate facts, custom, tradition, and law. He said the Mamprusis ruled Boku for 150 years before the arrival of the colonial authority. He also mentioned that the Kusasis, by their custom and tradition, are Tindanes. He said the Mamprusis, according to the Kusasis, the Mamprusis became chiefs of Boku at the time of the colonial authority. When the colonial authority came, they were looking for chiefs in areas where there were no chiefs. I mean, they were looking for chiefs. In areas where there were no chiefs, they appointed Tindanes as chiefs. It was at that time, or around that time, that the Mamprusis presented themselves as chiefs. That is the Kusasis narrative. And the Mamprusis got registered as such. So take note of the word registered. According to the Kusasis, the Mamprusis got registered as chiefs. Then in 1957, centuries after the colonial authorities came to Boku, and the Mamprusis got registered by the colonial authorities as chiefs, the Kusasis also in 1957 enskinned Aburago Azoka as their chief. And then their reason is that the Mamprusis were power drunk. Asantehene also told us that after the death of Aburago Azoka, the Kusasis again enskinned his son, Aninchema Abugarago, as the Bokunaba. And he is still the Bokunaba. So these are the facts. As already highlighted about hostilities, one, hostilities in Boku did not start with the enskinnment of Alhaji Sidu Abagare as Bokunaba. That is a fact. The other fact is that the Mamprusis have their custom and tradition and culture, which is partly chieftaincy. The Kusasis also have their custom, traditions, and culture, which is Tindan system. So the Mamprusis and Kusasis have two distinct practices. One practices chieftaincy system, the other practice Tindana's system. The Mamprusi chiefs of Boku got registered. It is just like saying today that a chief is gazetted. So we can argue that since the Mamprusi chief got registered by the colonial authorities in around 1907, according to the Kusasis, at that time, there was a recognized chief and traditional system based on customary law. Notwithstanding that, in 1957, the Kusasis enskinned a chief. of the same traditional area. In other words, they went against the law of the state, which is the registration of Mamprusi chiefs recognized by the government of the day. My dear brothers and sisters. So these are the facts that we need to take note. Now let's move on to the second video.
Son, as Asigiri Abugurabo Azoka, as the Bokuna. On the 6th of June 1957, while the then Nayiri was going through the various ceremonies in Nalurigu connected with the appointment of a new Bokunaba in the person of Mahama Yeremia, a Mamprusi prince, the Kusasis had gathered in overwhelming numbers in Boku to also elect and install Abugrago Azoka, a Kusasi, as the chief of Boku and the head of the then canton chiefs in the Kusasi area. This followed the death of Na Awuni, who was the Mamprusi chief of Boku and head of the Kusasi area. The enskinment of a Kusasi chief created a situation where there were two rival claimants to the skin of Boku, and all residing in Boku. Several petitions and representations were made to government of the day, which decided to set up a committee to inquire into the rival claims. The committee was made up of lawyer S.D. Opokua Ferry as chairman, Nana Yawa Ajimambadu, then Domahine, and Lure Canton III, the then Tumukro, as members. After the deliberations of the committee, they reported to the Governor General, Lord Listowel, then, that Abugrago Azoka has been customarily elected and installed the chief of Kusasi area. Abugrago Azoka thus became the first Kusasi Bokunaba and head of the Kusasi area. The records of the committee reveals that they accepted evidence adduced by him that his father and grandfather owned most of the land that constitutes present-day Boku Township. In the analysis of the committee, the Kusasis were the original inhabitants of the Kusasi area. The Mamprusis had invaded the area and began to install princes from Nalurigu to rule over the Kusasis. They suspected that the arrival of the Europeans might have added the establishment of Mamprugu hegemony in the area. At the time of the work, listed the same names, so restoring the names as it is now again. So Abugra Azoka becomes Bokunaba again. And Alaji Adam Zambio then is prohibited from becoming, from being Bokunaba. The passage of PND's Law 75 led to bloody clashes between the Mamprusis and the allies and the Kusasis and the allies. Other complementary measures were implemented by the PNDC to restore law and order. They included the Boku Lands Vesting Law, PNDC Law 99, which vested all lands in the Boku district and a PNDC free from all encumbrances, and the passage of the Prohibited Organization Boku District Law 1984, PNDC Law 98, which proscribed tribal organizations in Boku. Abugrago Azoka had died before the passage of PNDC Law 75. The Kusasis then enskinned his son as Asigiri Abugrabo Azoka as the Bokunaba and the head chief of the Kusasi traditional area.
All right, ladies and gentlemen. 5 salient points that I need to highlight from the second video. Asante Hini told us in his report that in 1957, whilst the Nayiri was going through processes in Nalurigu to enskin a Bokunaba, the Kusasis also gathered in Boku and enskinned their Bokunaba. Point number 3. by that conduct of the Kusasis, Boku had two rival claimants, two rival chiefs. Asantehene also told us that Abogrago Azoka is the first chief of the Kusasi people in their entire history since the creation of this world. And that when he passed away, before the passage of PNDC Law 75, his son, Aninchema Abogrago Azoka, was Enskinned Bokunaba. Now, let me emphasize that there is no dispute of the fact that Sheriga Alhaji Seydou Abagre is not the first chief from the Mamprusi side enskinned by the Nayiri. Alhaji Seydou Abagre was enskinned in 2023. And I'm saying that even from the report of Asantehene, his mediation report, it is established that the enskinnment of a chief from the Mamprusi people in Boku by the Nayiri did not start in 2023. In 1957, the then Nayiri, while he was going through the process of enskinning a chief from the Mamprusis, the Kusasis also decided to enskin a rival chief. So what is not in dispute is the authority of the Nayiri to enskin a chief in the Boku traditional area among the Mamprusis. My dear brothers and sisters, now let's move to video number 3.
The Constitution of Ghana, 1992, came into force with the Kusasis in place as the rulers of Boko. Asigri Abogrago Azoka was Bokunaba, and by virtue of that, he enskinned all the divisional chiefs in the Kusasi traditional area. Article 270, Clause 1 of the Constitution provides that the institution of chieftaincy, together with its traditional councils as established by customary law and usage, is hereby guaranteed. So the position of Asigri Abogrago Azoka seemed to have been frozen in time by the 1992 Constitution, until one Alhaji Ibrahim Adam Zambio mounted a challenge in the present Supreme Court. This 2003 action instituted by the Mamprusis before the Supreme Court, seeking to invoke its original jurisdiction, was discontinued without liberty to reapply under Article 270 and 277 of the 1992 Constitution and the Chieftaincy Restoration of Status of Chiefs Law, 1983 PNDC Law 75, which had then been repealed by the Statute Law Revision Act 1996, Act 516 in 1996. On Tuesday, the 29th day of April 2003, the Supreme Court of Ghana provided what legal analysts believe to be finality to the question of the Boko skin. The ruling was very short and yet profound. Report says, the application to discontinue is granted but without liberty to apply PNDC law, liberty to apply under PNDC law 75 and Article 270 and 277 of the 1992 Constitution. Cost of those days, 10 billion to the first defendant. Signed, G.K. Akwa, Justice of the Supreme Court, T.K. Aziz, Justice of the Supreme Court, S.A. Brobe, Justice of the Supreme Court, S.G. Beidou, Justice of the Supreme Court, Dr. S. Chum, Justice of the Supreme Court. Apparently, on the morning of the hearing of the matter, the plaintiffs instead sought leave to discontinue the case. The leave was granted, but the court directed that no one should come back to that court again pursuant to Articles 270 and 277 of the 1992 Constitution, the matter of the restoration of Abugrago, Azoka, and all other sub-chiefs under PND's Law 75. Under the 1992 Constitution, the Supreme Court has final authority to make such pronouncements, and only that court can review its decisions under certain circumstances. I've gone to great length to review the history of various legal resolutions of the matter and the involvement of the various military regimes to show that this matter has traveled a long, tortuous legal and political journey. In spite of the efforts of various courts and governments, the Memphis did not give up their claims, and the Kusasis did not relent in their efforts to assert their independence and identity as a self-ruling tribe. The Nayiri kept insisting that the Supreme Court has not ruled on the issues implicated in the Enskinned matter. Asigri Abugrago Azoka insisted that the Supreme Court gave finality.
When I
All right, my dear brothers and sisters, in the video that you just listened to, Asantehene did mention that before the coming into existence or operation of the 1992 Constitution, Ninchema Abogorago was already the Bokunaba. He also made mention of Article 270, I think Clause 1. He made mention of PNDC Law 75 and Supreme Court ruling, and of course, Kusasi's independence. Now, I just want you to listen to that part, but I'm not going to go into that because that is not about the trial of Sheriga. And I will explain why. So I'm not going to spend time on that. But I just want, since I want listeners to be well informed about the facts, and that is why I decided to play that part of the report. Now let's go to the last part of the report, then I will make my analysis.
Resolution of the Boko matters requires that Mr. Saidu Abagari be. The final resolution of the Boko matters requires that Mr. Saidu Abagari be recalled to Nalerigu by the Nayiri to be reassigned to play another traditional role at the palace of the Nayiri, assisted by the state. Alternatively, he may choose to stay in Boko as an ordinary citizen of the community, but not to pose as Boko Naba.
Let me replay this video, the last video, and please pay attention to that. From that video, we are then going into the trial of Sheriga. That is the significant part of the report that will smoothly lead us in the transitioning to discussing the trial of Sheriga. So let me replay that again.
Final resolution of the Boko matters requires that Mr. Saidu Abagari be recalled to Nalerigu by the Nayiri to be reassigned to play another traditional role at the palace of the Nayiri, assisted by the state. Alternatively, he may choose to stay in Boko as an ordinary citizen of the community, but not to pose as Boko Naba.
Now, that part is the recommendation of Otumfuo Osei-Tutu II from his mediation, and specifically talking about Alhaji Saidu Abagari Sheriga. He recommended to the Republic, to the President, that Alhaji Seydou Abagre should be recalled by the Nayiri to Nalirgu and reassigned a traditional responsibility. Or na Sheriga Alhaji Seydou Abagre may choose to stay in Boku, but he should do so as an ordinary native of the land and not pose himself as a chief. Now, lawyers will tell you that this particular part alone, lawyer will tell you that each word should be taken carefully and understood perfectly. Saying somebody should not pose as a chief has its own meaning. Now, but what is my point? What is my point? My point is that on December 24th last year, Sheriga Alhaji Seydou Abagre was removed from Boku, his native home, and taken to Accra and put on detention. Now, who did that and why? Let me read to you a report signed by the Minister for Interior, Muntaka Mohammed Abubakar, MP. It says, implementation of recommendations of the Otunfuo Nana Osei Tutu II on Boku affair. And I quote, this afternoon, personnel of Ghana Armed Forces removed Alhaji Seydou Abagre from Boku, pursuant to the recommendation of the Otunfuo Asantehene Osei Tutu II mediation report regarding the Boku affair. Alhaji Seydou Abagre is safe in the care of the security agencies. Signed, Muntaka Mohammed Abubakar, Muntaka Mohammed Mubarak, MP, Minister for Interior. So, per the Interior Minister, the reason why Sheriga Alhaji Seydou Abagre is in Accra under the custody of the state is because of the recommendations of Otunfuo Osei Tutu II in his mediation, right? Now, what did Otunfuo recommend in his mediation? Let me play that again. Let me play that again.
Resolution of the Boku matters requires that Mr. Seydou Abagre be recalled to Nalirigu by the Nayiri to be reassigned to play another traditional role at the palace of the Nayiri, assisted by the state. Alternatively, he may choose to stay in Boku as an ordinary citizen of the community, but not to pose as Boku Naba.
Now, is this very difficult to understand? The Interior Minister told us that the government removed Sheriga from Boku, his native home, and taken to Accra, and that Sheriga is safe in the hands of the government. Now, the Interior Minister told us that the reason why Sheriga was removed from Boku by the military, not even by the police, by the military, is pursuant to the recommendation of Otunfuo mediation. Right? Now, there is nowhere in the report that Otunfo recommended that Sheriga should be removed from Boku by the military and taken to Accra and detained. Let's get that right. There is nowhere in the report of the mediation where Asante Hini said the government should remove Sheriga from Boku and taken to Accra and put on detention and prosecute. Asante Hini said the government, Nayiri, should recall Seydou Abagre to Nalerigo, or Seydou Abagre could remain in Boku, but not to pose as a chief. One would have thought that if the Boku chieftaincy matter was not political, if the NDC government was not doing politics with this chieftaincy issue, and if the NDC government indeed respected Asante Hini and respected the recommendation of Asante Hini and was genuine to getting peace in Boku, the government would have communicated to the Nayiri that this is the recommendation of the Asante Hini's mediation. We want you, the Nayiri, to tell us, out of these two options, which one do you prefer? Do you want to call Sheriga to Nailerugu, or you want Sheriga to remain in Boku? Then the Nayiri will say, yes, this is the option I choose from the two, or I will not choose any of the two options. The government never did that. That is absolute disrespect to the Nayiri, who the government and then the report established that the authority of the Nayiri to Enskinned a Mamprusi as chief did not start in 2023. Did not start in 1957. But the Mamprusis ruled Boku for 150 years before the arrival of the colonial authority. Now, let's move to the real issue. So I've laid the foundation for all of us to have a better perspective. Now, what then happened? The government, upon taking Sheriga to Boku and putting him on detention, did so on what lawyers will call, or what the legal profession describe as ex parte detention or ex parte motion. They came with an ex parte motion. And in that ex parte motion, they told the court, this is the reasons why we want you, the court, to give approval to us to keep Sheriga in custody. Right? Now, let's listen to some of the things that the prosecution told the court. Let me show it on the screen so that you see it, feel it, as it is set in the local parlance.
Of the Boku matters requires that Mr.
So this is the affidavit. This is the affidavit. Sorry, this is the affidavit sworn by one of the detective inspectors and then presented to the court. I'm just going to highlight one or two things from this so that we will just understand what is going on. Let's understand the trial of Sheriga Alhaji Sira Bagre. Now, this is what the police told the court. He said, the National Intelligence Bureau are investigating a case of aiding and abetting vigilante activities, contrary to Section 21 and 3, 1, and 4 of the Criminal Offense Act 1960, Act 29, and the vigilantism and related offenses. That the accused sometime in the year 2024 Enskinned himself as rival Bokunaba in Nayiri and sneaked into Boku. So, my dear brothers and sisters, the police presented about 10 points. And out of these 10 points, I just want to highlight two, which is what I read. Let me read it again. Point number 3 in the affidavit, it says that the National Intelligence Bureau are investigating a case of aiding and abetting vigilante activities. Aiding and abetting vigilante activities. It went on to say, point 4, that in 2024, Sheriga Enskinned himself as a rival chief of Boku in Nayiri. Ghanaians, I hope we are following the trial of Sheriga very carefully. Among other things, the police told the court to get approval from the court to detain Sheriga, told the court that they were investigating, the state was investigating an alleged aiding and abetting of vigilante activities, and that in 2024, Sheriga Enskinned himself as rival chief of Boku. The court, for whatever reason, didn't verify to know the facts. I don't know how the law operates, whether because it is an ex parte motion or what, I don't know. But the court granted the state the right to detain Sheriga on the ex parte motion. My dear brothers and sisters, now let's then go into details. So, stage 1, ex parte application for detention. In other words, the police made an ex parte application for detention at the court, a court of competent jurisdiction. The prosecution went to court ex parte and obtained an order to detain Sheriga. Now, is that legal or not? What is the legal position? From my research, it is permissible by law, but only as one, a temporary investigative measure. Temporary investigative measure. 2, based on reasonable suspicion. Based on reasonable suspicion. And 3, strictly time-bound and exceptional. In other words, if you go on an ex parte application for detention, the law permits that. but that the ex parte detention must be temporary. It must be temporary. It must also be time bound. That is to say, within 1 week, let's say we want to detain him for 1 week or 2 weeks or 1 month or 1 year, right? It should be time bound. There should also be reasonable suspicion. Now, if you say that Sheriga Enskinned himself in 2024 as rival chief, where is that reasonable suspicion? If you say Sheriga is aiding and abetting vigilante activities, where is the reasonable suspicion? You need to go beyond just making allegations, right? The police did not do that. So just as the government did not follow the recommendation of the Asantehene mediation report and went on to do their own thing, it is the same thing that the state, acting by its agent, the police, also went on ex parte application for detention, doing their own things. Stage number 2. After detaining Sheriga for more than 2 weeks, right? More than 2 weeks, almost 3 weeks, they finally brought Sheriga to court. Now, when that happens, the law requires a couple of things from the state. One, once the accused is produced in open court, the Constitution fully applies. The Constitution fully applies. The moment you bring the accused person to court to present him for prosecution, the 1992 Constitution fully applies. So the law works. Put aside the detention and whatever, put aside. All that are required to be made in accordance with the law. But I'm specifically saying that when you take an accused person or a suspect or whatever to the court, you are acknowledging that the Constitution governing the country kicks in. It now takes full effect in its application. Now, if that is understood, then Article 19.2a then becomes very relevant here. That particular article demands that the accused be informed immediately, in detail, of the nature of the offense he is brought to court, he is charged. Ladies and gentlemen, we must take this thing serious. This is the conditional handover point from investigation to prosecution. Before, let's say, whilst the accused was at detention, you were doing your investigation. When you do your investigation and then you gather your facts and whatever, your evidence, you then take the accused person to court. At that time, that is the handover stage. You are handing over from investigation to prosecution, right? Then Article 19.2a requires that you tell the accused in detail the nature of his offense charged. Let me quote the article. It says, A person who is arrested, restricted, or detained shall be informed immediately in a language that he understands of the reasons for his arrest, restriction, or detention, and of his right to a lawyer of his choice. It is a fact that when Sheriga was taken to Accra up to date, he has been denied access to a lawyer. He has not been told why he was arrested. Then he was taken to court. Even at court, from my investigation, the prosecution did not even give the particulars of the charges against Sheriga. Neither did they give the facts of the case. And in law, when you present an accused before court and put charges on him, you are required to give the particulars of the charges and also give the facts of the case. Then the accused will take a plea, whether to plead guilty or not guilty. If you present an accused before court, put charges on him, and did not provide the particulars of the charge and also the facts of the case, it is incomplete. That charge or those charges are incomplete. And in fact, I will want to believe is unconstitutional and procedurally defective. But that is what happens. So I hope we are understanding the trial of Sheriga, the nature of the trial, Ghanaians. I hope we are understanding the nature of the trial, what is going on. Now let's go to stage 3. So stage 1 is the application for detention via ex parte. Stage 2 is the prosecution bringing accused to court. Stage 3, what is stage 3? Stage 3 is what I already highlighted. Charges without particulars or facts. And I'm saying that in law, it is against the Constitution. It is legally defective, my dear brothers and sisters. Now, let me play a 2-minute video of the lawyer of Sheriga. His experience, something he said small, I think in one of the TV stations, on one of the TV stations today. Let me share that with you, then we'll continue with the program.
Greeting, so for Kufu,
just a minute, hold on. All right, so this is Martin Kwebu. He is the legal representative or the lead counsel of Sheriga. I know he is not the only lawyer representing Sheriga in this case, but it appears he is the lead counsel. So let's listen to what he said today, not in relation to he didn't mention Sheriga, but he talked of his cases. But so let me just play and then let's listen to what he said.
This morning, instead of my usual ritual of greeting, so for Kufu, do the second, Garment and the rest, I want to talk about the police service. Just a comment. You know, over 30 years, and this is our experiment with our constitution, it's shocking that you still have some policemen who derive pleasure from just ignoring Article 14, Clause 3 of the Constitution, which mandates that you arrest a person bring the person to court within 48 hours. You know, in recent times, this is the second time I had to call the CID boss, Madam Donko, right, to draw her attention that her men are keeping or seeking to keep suspects beyond 48 hours.
Okay.
And yesterday it broke me when I had to contact her the second time, because I'm like, so would I have to always go and report to the boss that this is what the subordinates are doing? So Ghana Police Service, please, those bad nuts who derive pleasure in keeping suspects and accused beyond 48 hours, it must stop. Look, in 1969 Constitution, next week I'll bring it, it was 24 hours.
Thank you.
More than 50 years ago, it was 24 hours. Then somehow, Nigeria still keeps 24 hours. Nigeria, that we pride ourselves that we have better records, they still keep 24 hours. Right. Hours, for some reasons, I'm sure we are still digging into that. We're looking somewhere. Then it was extended to 48. It just means, listen, prepare before you arrest the person. Or if maybe you think prepare it before, that's investigate before you arrest. You think he will run away. Then as soon as you arrest the person, start typing. What does it take to type the case to present it to court?
Right.
No, it's just not on. Because yesterday when I called the second time, I was like, hey, just in the space of 2 months, 2 calls. So is it that every month I'll be calling the CID boss? No, let's not do this.
Right.
It's not good for our democracy. Okay.
Thank you.
Let's not do this. It's not good for our democracy. I think, somebody said you need to block the KUs for writing nonsense. My dear auntie, you just be patient with them. I understand your point, but discerning Ghanaians who want peace in Boku will make sense of what we are discussing. So for the Kusasis, I know they're out there to distract us and all that. So let's forget about them, Auntie. Thank you very much for your suggestion. Now, Sheriga was taken to court. And from my understanding, based on what I heard the lawyer of Sheriga say, Sheriga was taken to court on 4 charges. 1, he said acting or holding himself out as a chief. 2, provocation of riot. 3, offensive conduct conducive to the breach of peace. And 4, fighting with weapons. So these are the charges placed against Sheriga. I will share with you what I think the state will need to prove in these charges. But before I do that, let me just come out with some few questions and give you the answers. Since I'm not going to have the opportunity to give you to ask you to ask questions so that I will answer you. But I've made questions that I know every reasonable Ghanaian will want to ask me, right, on this program. So, for example, the question is, remember, I did say that Sheriga is not registered as a chief by the National House of Chiefs. So the question is, if he is not registered, isn't he acting illegally? That's a good question. If Sheriga is not registered by the National House of Chiefs, is he not acting illegally? The answer from my research, from questions that I have asked, the answer is no. And this is the reason why. Non-registration is not a civil disability. It is also not a criminal offense. Chieftaincy is about customary law. Now, Sheriga was Enskinned chief by the customary law and practices of the Mamprasi people. So, by that alone, you cannot say Sheriga must register with the National House of Chiefs. He may choose not to register. If he chooses not to register, it means that the state will not recognize him as a chief. It doesn't mean Nayiri will not recognize him as a chief. It doesn't mean the Mamprasis will not recognize him as a chief. Right? So, if he is not registered, it is not an illegal thing. Whoever is registered can be registered. Just that Sheriga cannot perform statutory functions that is assigned or preserved for chiefs that are registered by the National House of Chiefs. That is the only distinction. So let me take another question. So, for example, if you may ask, but there is already a registered chief. There is already a registered chief. So, in that situation, what happens? Again, registration resolved recognition, not customary legitimacy. So, as already explained, Aninchema Abogoraga Zoka is registered by the National House of Chiefs. Now, Sheriga is not registered. So, by that act, the registration, what it simply says is that there is no dispute between Sheriga and Naba Aninchema, who is recognized by the state. There is no dispute. So the registration of Naba Aninchema by the National House of Chiefs resolved the issue of which of the two is registered and which of them is not registered. So there's no dispute. So you cannot make it a crime for Sheriga because Naba Aninchema decided to register as a chief and be recognized by the state. That is his choice. His registration as a chief does not nullify the customary legitimacy of Sheriga, who is a Mamprasi and not a Kusasi. So that also. Now let's look at another question. You may continue to ask, so anyone can claim to be a chief? In that case, you may say, okay, so does it mean that anyone can claim to be a chief? The answer is no. And Section 63A of the Chieftaincy Acts applies here. It applies here. Let me restate. And how does it apply here? It only applies if someone is not customarily qualified is not customarily qualified. Even with that, that determination belongs to the customary institution and not the court. It is also not a criminal case. Last but not the least, isn't this encouraging lawlessness? You may ask, isn't this encouraging lawlessness? The answer again is no. And what is the reason? It is rather encouraging proper jurisdiction, customary matters to customary forums, crimes to criminal courts. And that is the reality, and that is the true picture of what is happening in Boku. It is a customary issue. It is not a criminal issue. If you say Sheriga is acting as a chief or posing himself as a chief, it is a customary matter. Sheriga, remember, Sheriga did not just sleep and wake up and say he is a chief. It is a customary matter because Sheriga forefathers have been Boku Nabas before. In fact, let me give you Sheriga's royal ancestry. When you come to the Mamprusi's traditional practice, their custom in the Boku traditional area, they have about 4 or 5 royal gates. Sheriga is from one of the royal gates. I am also from one of the royal gates. My royal gate is different from Sheriga's royal gate. So I can trace my royal lineage from the Mamprusi chiefs in Boku, different from Sheriga royal gate, even though at the end of the day, we will all merge at or converge at one particular individual. That said, Sheriga direct ancestral royal lineage, let me share with you. Sheriga is enskinned as a chief by the Nayiri. The question is why? Why? Because Sheriga is customarily qualified. Again, why is Sheriga customarily qualified? Why? Because Sheriga's grandfather was the chief of Boku from 1936 to 1950 by the name Na Yakubu Mamboda. Yakubu Mamboda's father. So let me take my time. Sheriga's grandfather was the 11th chief. Sheriga's great grandfather, Mamboda, that is Yakubu's father, was the 7th chief of Boku from 1844 to 1895. Mamboda's father was also a chief. He was the 5th chief of Boku from 1765 to 1829. Mahama's father was Mahamadu. He was the chief of Boku, the fourth chief of Boku, called Na Mahama Ali from 1754 to 1764. Na Mahama Ali, his father was also the chief of Boku, the first chief of Boku. That's Na Ali Atabia from 1721 to 1732. So customarily, Na Sheriga is qualified to be Enskinned a chief. All right, let's put that aside, my dear brothers and sisters. We are getting to the end of tonight's program. And I'm going to end tonight's program by looking at section 57.5 of the Chieftaincy Act, section 63B of the same act, and maybe I'll make an attempt on Article 270 of the 1992 Constitution. My dear brothers and sisters, again, before I go that, let me put one or two things into proper perspective and context. And this takes us back to the Otunfo's report. Now, let's remember that there is no dispute of the fact that when you come to the Boku traditional area, the Mamprusis have their culture, tradition, and custom different from the Kusasis. The Mamprusis culture, tradition, and custom is chieftaincy. And it is an established fact that in the Boku traditional area, it is the Mamprusis who established chieftaincy in the Boku traditional area and not the Kusasis. The Kusasis' custom, culture, and traditional practices is the Tindana system. That one too is an established fact. The Tindana system and the chieftaincy system are two different traditional institutions. And both institutions are independent of each other, independent in the sense that what is a Mamprusi culture is a Mamprusi culture. What is a Kusasi culture is a Kusasi culture. A Mamprusi cannot claim to be a Tindana because that is not the Mamprusi's tradition. In other words, the Mamprusi cannot be qualified to be a Tindana. Similarly, a Kusasi Tindana cannot be a chief because Tindanaship and chieftaincy are two different traditional practices. The moment the Kusasi Tindana want to be a chief, that is where the friction comes. You are in Tindana and you want to be a chief. Of course, there will be confusion, there will be problem. You are a chief and you want to be a Tindana, there will be a problem. Can you imagine that today, that the Mamprusi will say that he is the Tindana of Boku? If a Mamprusi says, or let me put it squarely. If Sheriga says that I am Tindana of Boku because my forefathers owns the land, what will the Kusasi say? The Kusasi will say, no, Sheriga, you are not a Tindana of Boku. Mamprusis are not Tindanes. That is not the tradition of the Mamprusi people. It's as simple as that. If Sheriga insists that no, he is the Tindana of Boku, the Kusasi will say, Lala, that is not the case. So why should the Tindana want to be a chief when chieftaincy is not their tradition? And remember, in the Otumfuo's report, the Kusasi told Otumfuo that when the colonial authorities came and they were looking at areas that had no chiefs, they were appointing Tindanas as chiefs. I asked this question, and let me ask again. Why didn't the colonial authorities appoint a Kusasi Tindana in 1907 as Bokunaba? Where was the Kusasi Tindana at that time? Where was the Kusasi Tindana when the colonial authorities were appointing Tindanas in areas where there were no chiefs? All right, my dear brothers and sisters. So I needed to highlight that so that we all understand. But once again, the topic tonight is the trial of Sheriga Alhaji Sidu Abagre, a customary chief Enskinned by the Nayiri. Ladies and gentlemen, Article Section 57, subsection 5, or clause 5, if I'm saying it the right way. What is it all about? Well, Section 57.5 of the Chieftaincy Act says that a person shall not be considered a chief for the performance of a function under the Act or any enactment unless registered. A person shall not be considered a chief for the performance of a function unless under this Act or any enactment unless registered. Again, as already explained, what this particular section is saying is that the Chieftaincy Act spelled out functions recognized by the states that a chief must perform or is expected or is required to perform or is allowed to perform. Let me put it that way. If you are not registered, the Act doesn't regard you as a chief, and so you cannot perform those functions. In other words, though Sheriga is a chief per the Mamprusi custom and tradition, the Chieftaincy Act does not recognize Sheriga as a chief. So Sheriga cannot perform statutory functions of a chief. But that does not mean that Sheriga is not a chief. Let's get that right, fundamentally. It only means that he is not recognized. The state will not deal with him in any way, and he cannot present himself to the state as a registered chief. But he can say that, yes, I am a chief per the custom and tradition of the Mamprusis. I am the chief. I am a chief. Has Sheriga performed the functions that, let me say, Aninchema Abugragwa Zoka is supposed to perform? I don't think so. So, what offense has he committed? Just because he is a chief? In any case, Boku traditional area is not the only traditional area that you can find two chiefs, where one is recognized by the National House of Chiefs and the other is not. So why not go and then arrest all those who are not registered in those traditional areas and put criminal charges on them? Why not do that, but rather Sheriga and the man proceeds? It just tells you one thing. This is politics. It is politics. My dear brothers and sisters, if I may explain further about or on Article 57.5, what it means is that registration is equal to state recognition. In simple words, registration is equal to state recognition. If you are not registered, it is not equal to crime. If you are not registered, it is not equal to a crime. Again, if you are not registered, you do not lose your customary identity. So if you ask Sheriga today, are you a chief? And Sheriga say, yes, I am a chief. That is a customary identity bestowed on him by the Nayiri. Because he is not, his name or information is not recorded in the National House of Chiefs, doesn't negate that one. Now let's look at section 63A. Section 63A. And why this is important, because remember, I may not be able to go into the 4 charges brought against Sheriga for lack of time. So I chose to just pay attention on the first one, which is, he said, what, acting, let me get it right. Is it acting as a chief, right? Yeah, acting as a chief, right? And section 57.5 and 63A are all from the Chieftaincy Act. Chieftaincy Act. So that is why I'm putting more emphasis on those. Now, section 63A is about not qualified, right? Who is not qualified. And that particular section criminalizes acting as chief when one is not qualified. It criminalizes one acting as a chief if one is not qualified. So, for example, no wonder why the police or the state labeled that charge as their number 1 charge on Sheriga. But what that section is saying is that it becomes criminal on you. Let me use Sheriga as a case study since we are discussing his trial. It becomes criminal on the part of Sheriga if he is acting as a chief when he is not qualified. So the question is, who is qualified to act as a chief? One who is qualified to act as a chief gains that qualification from customary law. not Supreme Court ruling, not Parliament, not the Constitution, not PNDC Law 75, not any statutory law, and even not the National House of Chiefs. It is based on customary law. Again, what that meant is now Sheriga qualified to act as a chief? And the answer is yes. Why is the answer yes? As already told you, now Sheriga was enskinned as a chief by the Nayiri of Mamprugo. And that is in accordance with the Mamprusi custom, tradition, and practice. So you then go further to ask, did the Nayiri enskin a qualified person to act as chief? Yes, because now Sheriga's grandfather was a chief. His great-grandfather was a chief. His great-great-grandfather was a chief. His great-great-great-grandfather was also a chief. So he's qualified. Let me give you a typical example of who is not qualified as a chief. One, Mahama Ayaraga is not qualified to act as a chief. Cletus Avoka is not qualified to act as a chief. Right? Because Cletus Avoka's father has never been a chief. His grandfather has never been a chief. His great-grandfather has never. So he is not customarily qualified. So is Ayaraga. I am customarily qualified because my grandfather was a Bokunaba. It was after the death of my grandfather that the Nayiri was about to enskin his successor, that the Kusasis enskinned arrival. My great-grandfather was a chief. My great-great-grandfather was a chief. So customarily, I am qualified to act as a chief. But as it is now, I cannot act as a chief because until the Nayiri enskins me as a chief among them, in accordance with the Mamprusi tradition and custom, I cannot act as a chief. So that is what section 63A is all about. Now, let's look at section 63B. 63B is also about what? It says, it applies only if a chief assumes a position he is not entitled by custom. So let's make assumption that Sheriga is assuming a position as a chief. The question is he entitled to assume that position by custom and not by PNDC Law 75, not by Supreme Court ruling, not by NLCD 112 or whatever you may call it, but by custom, guaranteed by the 1992 Constitution, customary law, right? So you may also ask rhetorical questions such as, who decides entitlement? Who decides entitlement? The answer is very simple. Customary authorities and not court. Customary authorities like the, the Nayiri, right? And not court. That is why I keep on saying not in the Supreme Court, not PNDC law. No. Customary authority. Indeed, if you look at Aninchema Abogrago Azoka, or let me say the Kusasis chiefs, Aninchema Abogrago Azoka, the current Kusasi Bokunaba, and his father. His father was not enskinned by any law. His father was enskinned per the custom of the Kusasi people. That's customary law. My research from the National House of Chiefs record also indicates that Aninchema Abogrago Azoka, it is recorded that he was enskinned by custom and not by PNDC Law 75. So this issue of PNDC Law 75 and status quo ante and whatever, listen, the chieftaincy institution has its own nuances. But again, I'm not going to go into all that. I will leave that to the lawyers. But I'm saying that even those talking about PNDC Law 75, for example, Asante Hini said the PNDC Law 75, what before the, the coming into being of the 1992 Constitution, the Kusasi current chief was Bokunaba. Asante Hini also told us that even PNDC Law 75, when PNDC Law 75 was passed, the first Kusasi Bokunaba had died. Right? So PNDC Law 75 only restored his status as a chief. And then that status is what? Recognition. The PNDC Law 75 said, okay, we NLC 112, NLCD 112 refuse to recognize you as a chief. For whatever reason, you died, you passed away. The PNDC government, even though you passed away, we want to recognize you as a chief. So PNDC Law 75 is specifically about Abogrago Azoka and not Aninchema Azoka, and not Aninchema Abogrago. PNDC Law 75 did not enskin Abogrago Azoka as chief. It restored recognition to him as a chief. It is on the basis of that restoration that Aninchema Abogrago then became customarily fit among the Kusasis to succeed his father. Let me explain. In 1957, when the Nayiri was in Nalerugu, the Nayiri was going through the process in Nalerugu to enskin the successor to my grandfather. That was the customary aspect of it. It wasn't about law, right? The Nayiri did enskin a Bokunaba, Nayirmia Salama, my grandfather. One of my grandfathers, let me put it that way. That is customary law. That is custom. When the Kusasis also decided to enskin their Bokunaba, it wasn't a law that was passed saying that Abogrago Azoka, you are the chief. No. The Kusasis also said, we have our custom our way of inskinning a chief. And by that custom, we have inskinned Abugrago Azoka as a chief. Again, that is customary law. So there is nowhere in the history of Ghana that a law has ever inskinned an individual as a chief. Before and after the 1992 Constitution. And it will never ever happen. So let's get that right. Now, having understood it that way, in 1957, there was nothing like PNDC Law 75. In 1966, NLCD 112, a new government, refused to recognize Abugrago Azoka as a chief. And he died. I don't want to go into the decision of the National House of Chiefs. Let's not complicate things. Let's make things simple. NLCD 112 refused to recognize Abugrago Azoka, who the Kusasi inskinned customarily as chief. So he died in 1983. When he died in 1983, PNDC government was in operation. Then the PNDC government said, no. There was a man called Abugrago Azoka who was customarily inskinned. But NLCD 112 said the government will not recognize him as a chief. Remember, the NLCD 112 did not diskin him. It refused recognition. When NLCD 112 refused recognition, it means that Abugrago Azoka cannot present himself as a legitimate chief recognized by the state and act and perform statutory functions. But among the Kusasi community, the Kusasi still recognize him as their chief. So when he died, then PNDC Law 75 came. And PNDC government came. So PNDC government came, then the Kusasis took the matter to the PNDC government and said, listen, this is one of our chiefs, or our chief. He was customarily inskinned. NLCD refused him recognition. Now he died. If he is not, if his status is not restored as chief, we cannot inskin another chief. So PNDC Law 75 then restored the dead person's status as chief, his recognition as chief. There was no anything like 1992 Constitution, where you'll be talking about status quo ante. Let's not confuse ourselves. Right? Now, let me explain. I'm ending this program, so I want to emphasize on this. Why I'm saying that status quo ante, that Martin Hamidu is talking about, that the Kusasis are talking about, that some lawyers are believing, it is not applicable here. Why? Aninchema Abugrago Azoka, the current Kusasi chief, or let me put it this way, the current registered Bokunaba, was not inskinned as chief by PNDC Law 75. he doesn't have any entitlement to PNDC Law 75. He doesn't have any direct benefit to PNDC Law 75. PNDC Law 75 was designed for his father and not for him. That is why when you go to the records of the National House of Chiefs, it will tell you that Na Adam Zangbeo, who PNDC law refused recognition or destooled, it is recorded there that Na Zangbeo was destooled by PNDC law 75. It is not recorded in that record that Aninchema Abogrago was enskinned by PNDC law 75. It says that he was enskinned customarily. In other words, PNDC law 75 was is a non-starter as far as the status of Aninchema Abogrago is concerned. PNDC law 75 is an issue as far as his father is concerned. And I'm saying that that was just a recognition and not an enskinnment of his father. So after that recognition was given to his father, the Kusasis then said that, okay, now that our father has been given recognition as chief, remember he died a commoner, even in the records of the National House of Chiefs. When PNDC law restored that recognition to him, then the Kusasi then said, okay, now we can now do customary enskinnment of his son, because the argument will be that his father was a chief. So there is no anything like status quo ante or accrue rights as far as PNDC law 75 is concerned. And I'm also saying that there is nothing like status quo ante to Aninchema Abogrago Azoka, even though he was the chief before the coming into existence the 1992 Constitution. Now I will explain why. That takes us to Article 270. That takes us to Article 270. Remember, the Asante Hini mentioned Article 270. Martin Hamidi too is mentioning Article 270. The Supreme Court mentioned, right? So let's look at Article 270. You see, if you don't take your time to study the facts, to go deep into law, somebody can just use something simple to confuse you and make you believe a lie. If one person presents an argument that this is my understanding of this ruling, it doesn't mean that it is absolutely correct. Another lawyer can present a different argument, and the law court will look at it and say that, oh, between the two of you, we go with this reasoning. So that is why we don't have to take anything Martin Hamidu tell us as as the gospel fact of the law. Anything Asante Hini tell, no. But I'm happy that Asante Hini said, if anything, test the law. If there's an opportunity for you to test the law, test the law. And let me make this point before I come to Article 270. What that therefore means is that there is no need for Asante Hini to make recommendation that Sheriga should be recalled or stay in Boku as an ordinary person. What Asante Hini should have just said is that from my mediation, Aninchema Abogrago Azoka is recognized and should be recognized because he is registered, blah, 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 all that. Right? and because he was customarily enskinned and registered by the National House of Chiefs. Anyone who is not satisfied with that should take him to court or any other avenue and leave it like that. There will not be the political prosecution of the need for political prosecution of Sheriga. If Sheriga or the Mampusis are not taking Aninche Mabugrago to court, it means that he continued to be who he is. Simpliciter. That said, let's go to Article 270. Article 270 of the 1992 Constitution, as we have all come to understand, protects chieftaincy institution. It protects the chieftaincy institution and also bars Parliament from creating or abolishing chiefs. Parliament cannot decide to say this is a chief and this is not a chief. The president cannot decide to say this is a chief and this is not a chief. Asante Hene cannot decide to say this is a chief and this is not a chief. Article 270 bars those individuals and any institution like that. Right? Now, since Article 270 bars Parliament, the executive, and any other person, right, from deciding who is beside based on customary law, from deciding who is a chief and who is not a chief. What it therefore means is that any reading of Section 57 and or 63 that criminalizes unresolved custom violates the Constitution. The chieftaincy dispute between the Mampusis and the Kusasi started in 1957, and it has not been resolved. So if Parliament comes out today to say that we recognize Aninche Mabugrago Azoka and not Sheriga, it's a violation of Article 270. If Asante Hene says so, it is a violation of Article 270. That is why in the Supreme Court ruling, even though Supreme Court referenced Article 270, Supreme Court never said that the Supreme Court henceforth recognizes Aninche Mabugrago Azoka as the Boku Naba, or the Boku skin belongs to the Kusasis. The Supreme Court knows this very, very well. The Supreme Court itself is subject to the 1992 Constitution. That is why the Supreme Court said, don't come to us, we the Supreme Court, don't come to us to talk about chieftaincy. And when I wrote my letter to Mahama Yaraga, I pointed out this. The Supreme Court did not say that don't go to National House of Chiefs, or you cannot go to National House of Chiefs to talk about chieftaincy. It did not say you cannot go to High Court to talk about chieftaincy, or wherever you may want to go. It says don't come to us. Don't come to us doesn't bar you from litigating. Let's get that. People keep confusing people on this. Right? And I read in Martin Hamidu's talking about status quo ante coming into existence of the 1992 Constitution, blah, 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 all that. It is Martin Hamidu input that Asante Hene captured in his report. And I'm saying that if you don't take your time and draw the distinction, when was PND's law passed? Why was it passed? Who was it meant for? That is how you need to do the analysis. Was PND's law 75 for Abugrago Azoka or Aninchema Abugrago? My dear brothers and sisters, now this is my closing statement. This is my closing statement. Chieftaincy disputes are ancient. The law was designed to manage chieftaincy dispute, not to replace them with handcuffs. When criminal law enters unresolved custom, it is not justice that wins, but rather confusion. My dear brothers and sisters, this has been the trial of Sheriga Alhaji Sidu Abagre, a customary chief Enskinned by the Nayiri. I am yours truly, Dobia Mawuni Bakutoma na Atabia II. And as I indicated from the onset, this program is, let me issue my disclaimer again. This discussion or this program is purely for legal education and public understanding. It is not intended to prejudice any ongoing case, disrespect any court, or influence judicial proceedings. The analysis that I presented today to you on this program is based solely on Ghana's constitution, which I already referenced, Article 270, and criminal procedure law. My dear brothers and sisters, God bless you. Long live Mamprogu. Let's stay together. There's a lot that I need to share, and there's some of the things that I need to share. There are things that shouldn't be public. But trust me, Mamprogu, Satimi Dima, I'm not bragging. There's a lot that we need to do. There is a lot. I have a lot of things under my sleeve that I want to share. You can talk about politics. You can talk about what? But all I can say is we need to step up and we need to sit up. I am not happy. Personally, I'm not happy. And sometimes it hurts me when I see that we don't learn from our mistakes. And I'm being honest with you, even the prosecution of Sheriga, the way things are going, we still have not learned our mistakes. We have made mistakes in the past on court issues. From where I sit, from what I know, we have not learned mistakes. And sometimes I can just see us heading towards a certain direction that I said, if Bakutoma talk, we will say that he's too known. But anyway, each and every one of us will do his or her part and leave the rest to God. Posterity will judge all of us. Peace, and God bless you all.